Valerie Henderson. I'm on the West Region, and today what I'd like to do is cover a open memo training for you that you can hopefully adopt at your upcoming open memo trainings in the next couple weeks. One of the things that I think is unique about this training that sets it apart from the other types of classes that we tend to give is that it really focuses strongly on the legal research process. And the reason I do that is because the writing instructors traditionally don't seem to kind of tie it up in a bow for them and really make them understand what you're doing and why you're doing it. So I try to provide the students with a list of rules and criteria so that they can then feel like they're more confident researchers on Lexis Advance. I have done this type of training for a long time, and I have seen really powerful preference results, not only in my own account, but also in mentoring other reps across the country, that when we work together to adopt this kind of approach of training, there has been a real increase in preference among the first year class. So how I want to set it up, and what my team found most helpful when I was doing this for them, is to sort of give the training, but then sort of hop out of that role and kind of editorialize to you, the reps, why I chose to do that, or maybe like, here's another way you can approach that, or something like that, just so that you can kind of understand the overall background. Just to take a step back before we hop into the training, I just also want to say this, and this is probably more applicable to the newer reps. When you give an open memo research training class to the first years, in order for it to be effective, it must be tied to when they get their open memo assignment from Legal Research and Writing. So right now, if you are listening to this recording and you do not know when the 1L assignment is being distributed, you must immediately contact your writing professors and ask them, when does this get distributed and when do the students turn it in? You want to be able to offer the training class the first week that the memo is distributed. And then that way, and then this is the other thing that's important, when you send a note to the students advertising the class, make sure that you put in the regarding line, the subject line of your email, exactly what your legal research and writing professors are calling this particular assignment. Some people call it trial brief. Some people call it appellate brief. Some people call it open memo universe. They have like a million different names, but in order for it to really resonate with the 1Ls, you want to be able to call it that in your subject line so that they open up the email. So a lot of you guys have probably already set that up, but for those of you who haven't, I just wanted to make that point. So you'll see here that I'm trying to tie in the differentiators of our product with the legal research process on Lexis. And oh, and one more thing before I get started, and then that's it. I give them a plan, a research plan for how to approach legal research on Lexis. And as part of your listening to this, we will provide you with that particular plan. I will talk about the legal research plan inside this recording, but just know that you will also get that as an attachment so that you can also talk to it. And it's important that you refer to the handout in your training so that they know to bring it with them when they leave. Because if you don't ever talk about the handout, then they leave it on the table. So, okay. All right, so that's it. And now I'm going to get started with the training, and I'll kind of pop in and out of the role. So, hi everybody. I'm Valerie Henderson. Thanks for coming to the open memo class that I'm having today. What I'd like to do today is set up for you a research plan on how to approach the open memo that you've just been given by your legal research and writing professor. This is not just a research plan for this one particular memo, it's your research plan for life. This is something that you can use on Lexis for any kind of research assignment that's given to you from now to the time that you are a partner in a law firm. So what I want to say is this: it's important, and this is obvious, that you read the memo really thoroughly so that you have an understanding about what the major facts and the major points of law are that are being discussed. So that's, the first thing. The second thing that I want to say, and I've written this down on your handout, is, and this is key to doing focused legal research, is you want to be able to start off with the right search terms. So I'm just going to give you a little bit of little rule about what you want to think about. What search terms do you put inside the box? So generally speaking, you want to lead with the law. And what I mean by that is you want to lead with the cause of action that's at issue for you. And don't focus really heavily on the facts yet. The facts come into play later, but it's important for you when you're heading out that what you're looking for is an in-depth discussion of the cause of action that is central to the analysis of your legal research and writing paper. So for your particular assignment, I know I've spoken to your writing professors, and I know that you need to submit to them 10 cases and a treatise. And you have to justify why these 10 cases are important and what is important about the treatise that you picked. At the end of this class, I want you to feel confident that you can achieve this on Lexis. You will be able to get your 10 cases, figure out why they're important, and submit it to your writing professor and feel good about the work that you did. So we're going to think about right now what's important in our particular hypothetical is to understand our facts in the hypothetical that I'm going to give you right now so that we can then apply the legal research plan to it. So in my set of facts, and this is in California, there was a car accident, and the stepsister witnessed her stepbrother get into a car accident. Okay, so she was standing on the street and she watched somebody, the defendant, come and hit her stepbrother, and now she's going to sue for negligent infliction of emotional distress. So if we're going to apply the first part of the plan, which is we want to lead with the law, what would be the cause of action that we would want to lead with and not talk about any facts yet? Okay, so at this point, you hope that someone says, oh, the cause of action is negligent infliction of emotional distress. So I say, yes, that is exactly what we're going to lead with. So I'm going to, right here, type it in. I'm going to quote negligent infliction of emotional distress, and I'm going to click search. Okay, now this is important. Where you end up, your default is probably set to cases right now, that would be the first screen that you're going to hit after initial search. Now I know this might sound counterintuitive to you, but I'm going to ask, as part of your legal research plan for life, that instead of you jumping right into cases and trying to figure out what the major, most important cases are and how the law is really working, it actually takes you more time to read cases and try to figure it out on your own than if you instead kind of scooted down a little bit to the secondary material tab, which is where I'm going. Click on that and look for a treatise that can help explain the law to you. Remember that attorneys rely very heavily on our treatises to do legal research, and you should too. We are really present in the marketplace, particularly in Southern California, and our treatises are huge in helping attorneys practice law. And the reason for this is because they've already learned that lesson, that it takes too much time for them to figure out the law in cases, and they want to go to the expert, the guy who wrote 5,500 pages on this particular topic, and have him explain it to you. So that's the first part. The second part of the plan. The first one is you lead with the law. So that means that you're going to look for the cause of action that's at issue for you. And the second thing is you are going to move your tab from cases over to secondary material. And the reason I'm doing that is I'm looking for a treatise that can better explain the law to me so that when I go finally to read cases, I can be more discerning about which I should include in my top 10 list to my professor. So, okay, so now what I'm going to do is I'm going to narrow this thing down a little bit so I can get a more on-point answer set. First thing I'm going to do is I say, okay, you know what? I know I'm in California, so I'm going to narrow by California. Now I want a treatise. So it tells me here, just so you see, so you're like, it leaves me here with a law review. There's nothing wrong with law reviews. It's just that treatises are more organized for actual practice, and it's easier for you to kind of figure out how the elements are working in a particular area of law. So I'm going to click over here on treatises. Oh, whoops, sorry. Okay, now here's a list of treatises. What I've noticed in the past from watching you guys research for a long time is that you feel sort of like you're wasting your time by going into a treatise because you could just be picking your 10 cases, and why are you doing this? I want to give you a set of rules and kind of criteria that you can use so that to make sure that you feel like you're in the right place in the treatise to actually get good information that you need. So I'm looking at this and I think to myself, you know what? This is how I do it, okay? I just kind of read the top title. Now, California Forms of Pleading and Practice is a really, really powerful treatise that attorneys use heavily in practice, and it's very easy to understand and well laid out. So I look here and I think, okay, you know what? This is mental suffering and emotional distress. Part 3, research guide. Okay, well, yeah, I'm interested in the research part of it. And then I look over here and I say, well, maybe what's this one? Mental suffering and emotional distress, legal background. Now, if I was just starting out my research assignment, I would probably click on the legal background because that's what you're kind of looking for, is the backgrounding of the law that's going to set out those like major seminal cases that your writing professors are going to be looking for in your set of 10. So I'm going to click on number 2. Okay. So again, I kind of just read the title to sort of, give myself an idea about where I was. Okay. So now I'm actually in the book. Now, where am I? Why am I here? And what's important for me to look at? And what should I do first? Okay, that's what we're going to focus on here. Okay, you are inside this book. You are in section 362.11. The first thing I want you guys to do when you open up treatise is to click over here on the table of contents. Oh, sorry. The reason I'm asking you to do that is because you can see here that it's laying out kind of, okay, so there's intentional infliction of emotional distress. Oh, negligent infliction of emotional distress. Good, that's what I want. And then it kind of gives me defenses. So if that was also an issue to me, I knew that I could get a discussion of that as well. So what you want to do is you can open up this section over here, and it's going to kind of lay out all the major issues and elements that are at issue for you. So just to review our set of facts so that we can kind of further understand how to use a treatise effectively, my set of facts say that a stepsister was watching a stepbrother get into a car accident, okay? Now I'm going to give you one extra fact. The stepbrother and the stepsister do not live together, and they are grown adults. So I say, where would I want to click to get the most on-point discussion based on what I'm looking at? Well, if it were me, I probably would go to injury to third parties because the defendant did the accident, the stepbrother was in the accident, and the stepsister is the third party, okay? She's the one who's viewing it. So I'm going to click over here on this little arrow, injury to third parties. Now, as I scroll down here, this gives me more information. Bystander and direct victim recovery, liability to physical injury, person injured. I could probably click on a lot of this stuff and get good information, but in the interest of time, I know that recovery of the precipient witness is the actual point that I want to be in. Now, if you and I weren't hanging out together and you were looking at this book all by yourself, you might be like, wait, where do I click? What do I click? Don't worry about it. You can click on A B and C. And when you get to C, you'll know you're in the right spot. So I'm just going to click on C right now. And this is going to open up that particular part in the book, okay? So that is kind of how I want you to work through a treatise. You want to really know how to harness this particular expert's opinion, not opinion, this person's, expertise in negligent infliction of emotional distress, and you can really do that well by working with the table of contents. So now, this is really key, and it's the third part of the plan, and this is a key piece of doing legal research for you, and that is understanding the elements. Most legal issues are broken down into various different elements. And what your work is as a lawyer, and in this particular research project that you're working on, is to figure out, when looking at all the elements, can my plaintiff that I'm representing meet all the different elements that are set forth by the court? Now, what ends up happening is that not all elements are created equal. So you'll see here, it gives you discussion, recovery of the precipient witness. So in general, it kind of sets it out that they are owed a duty of care. And here you see, oh wait, the minute you start seeing 1, 2, 3, 4, those are the elements, and that is what is going to be central to figuring out what cases you want to pick and how your analysis is going to break out. So as you read this, you can say, okay, so the first element is that it has to be closely related to the injured victim. You have to be present at the scene, you have to be aware that something's happening, and there has to be serious emotional distress. So as I'm reading this, I think to myself, well, wait a second. It's a stepbrother and a stepsister, and they don't live together. I might not be able to prove closely related. That is going to be the element that is most at issue for me, the element that's going to be the biggest discussion, the biggest debate, because I can tell I'm going to be okay probably proving my other 3 elements. So now that I know this, I want to read closely the discussion that's happening here under closely related, and maybe potentially link out to some of these cases, read them, save them in a folder. Just to break out for a second, I know you guys already know how to do folder saving, so I'm not going to show you. I'm not going to show you that, but just so you know, I kind of interjected at this point. Okay, so this has been really a key maneuver for you as trying to figure out what 10 cases that you're going to want to submit, because you already have a few here that you can go from. And generally speaking, when you go to the treatise and there's this case cited in there, that is usually the major cases of law that your writing professor wants to see. Usually they want like 2 or 3 cases that set the major rules out, and then the other cases are kind of tinkering with the facts, and they're looking for cases that are interpreting those particular elements. So in other words, the court would be trying to decide, okay, well, what does it mean to be closely related? Is a stepbrother, stepsister enough? That kind of thing. So now that I know all of this, I'm actually ready to move on to case law, okay? So I'm going to scroll back up to my page, and I am going to go up here to my history, and I'm going to pull my initial search. Okay, so here I am. I am back at this left me at cases, just so you can see that, okay? So now I'm on a new screen. I went from secondary material to cases. So what do I do now? What's important? And what do I look at? That's what we're going to address right now. So first off, I'm going to refine by California. Okay, and I want to point out a couple things. Lexis has a powerful algorithm that will sort cases by those that are most relevant. So there's always something to be said by reading the first few cases that come up. And you can tell immediately that Thing v. Lechuza is your third case, and it was also a case that appeared in your treatise. So that is a good indicator to you that, you know what, that might be a case I want to take a look at. I've now seen it in 2 places. So before we take a look at Thing, I want to talk about another issue that is traditionally takes practice for new researchers, and that is narrowing down. I think of all the things that you do as a legal researcher in law school, narrowing is probably the most challenging, particularly if you're working with a set of facts and a legal issue that has been very, very heavily litigated. It's really hard to narrow down so that you don't have to read so many cases that aren't on point. You really want to just get down to a list of cases that are relevant to your issue. So let's talk about how to narrow for just a second. Okay, so let me just say to you guys, the reps really quick. A lot of the how you give the rules of how to narrow kind of depend on whether or not your school teaches terms and connectors, okay? I have one school that teaches terms and connectors and one school that does not. So depending on where the student is in their legal research process, depends on how detailed you want to get in the narrowing down process. I offer them 4 different ways to narrow, and I spend a lot of time on it because I know that this is something that they get really frustrated with. So if I can give them, an opportunity to be better at something like this, they love Lexis. So just so you know, that's why I spend a lot of time on it, and I'm going to give you everything, and then you can decide, what works best for the environment at your school. So, okay, so now I'm back. So, okay, you will see here that we have 2,060 cases. Now let's think about that. You only have to cite to 10. So you don't want to read 2,000 cases. I know that. So let's talk about how to narrow things down. These are your rules for how to narrow down an answer set, okay, on your cite list. We're going to go over here where it says search within results. And what I'm doing is I'm going to search within my 2,000 for cases that also use these additional terms, okay? So, rule number 1. The first thing you want to narrow by is the element that is most at issue for you. We talked about this when we read the treatise. See, this is why you go to the treatise first. I'm now informed about what the element is that is most at issue for me. I know the debatable element. It's whether or not the plaintiff is going to be closely related enough to her stepbrother. That is the issue that's the hardest for me to prove. And that is the element that I want to use to narrow down. So I'm going to say closely related. Whoops, sorry, I spelled that wrong. Actually, it's kind of small on the screen. Hang on. So I'm going to say closely related. As an aside to the reps, yes, there's a lot of different ways you can do this with the terms and connectors, but I'm just going to keep it simple. So, rule number 1, you narrow by the element that is most debatable. Okay, so I'm going to do that. That takes me to 152 cases. That is a huge weeder outer. Just focusing on one element took out, more than 1,500 cases. So, number 2, the second way you narrow, you can narrow by a legally significant fact. Now, sometimes your writing professors call this a material fact. And not all facts are created equal. That's very important for you to know, okay? Whether or not the car that was in the accident was red or blue does not matter, because it doesn't change the analysis, the legal analysis that you are going to be doing in this particular memo. The only facts that are legally significant facts are those that are central to the analysis. So in my circumstance, I am trying to figure out what it means to be closely related to another person. What does that mean? That's the crux of my argument, and I'm looking for cases where the court is going to interpret the words closely related. Are they closely related? What does that mean? So I want to know if a relative is considered closely related. Now, if I focused on just stepbrother or stepsister, that might be too specific. You can stick it in there if you want, for sure. But in order to capture a lot of different cases, maybe you could be a little bit broader and say relative or family, something like that. And then click search. So my first way to narrow is by the element that is the at issue, the biggest debate, and that would be, in my circumstance, closely related. The second way you want to narrow is by the elements that, is by the legally significant fact. Okay, and you guys wrote down what the definition is for a legally significant fact. Now I'm down to, if you'll notice, 117 cases. Great. The other way to narrow is this. Okay, now I know you don't learn the terms of connectors, all right? And I'm just going to give you one connector. That's it. I don't care if you learn anything else. If you just learn this one, it'll really help you a lot. And that's for the following reason. Many times when you are researching, you're actually looking for the intersection between your fact and your law. So what that means is you're looking for the intersection between your legally significant fact and the element that's most at issue for you. So you could do it, and it gets a very on-point answer set if you do it something like this. Closely related / P within the same paragraph. That's the only one I want you to remember. Closely related within the same paragraph as, and I'm going to put relative here. Or I can add in family. And I'm going to click search. And now I'm down to 30. I'm getting, then you can see here, the number of family members who might seek damages on the basis of. So you know that you're getting close, okay, that you're on to something. You've gone from 2,000 to 30 by applying the following rules, okay? So the final way, and this is it for the narrowing. I know I'm giving you a lot, but the reason I'm spending this much time on it is because I know it's something that is difficult to do when you get a really large answer set and you don't want to read them all. The final way to narrow is this. Sometimes what's actually at issue in the case is the test or the standard that the court is using. So let me give you an example. You guys have read a lot of cases by now, and I'm sure you have noticed that the court does something like this. Well, what would a reasonable person think? What would the totality of the circumstances be? What is the likelihood of confusion over this particular issue? Those are standards or tests that the court is setting out, and they're looking for facts that can add up to the totality of the circumstances or something along those lines. So sometimes that is what is most at issue for you, is what I want to find cases that are interpreting the test. So you would use the test or the standard in order to narrow down your answer set. So that's 4 different ways. I'm glad you guys took notes on it because this is your plan for life and you'll need it later. So now we're down to 30 cases. That's pretty good. In fact, maybe it's even a little too narrow. I might take out some of these, so I'm not too specific. I don't want to miss something. But what I think I'm going to do is I'm going to start here with the Thing be Lechuza case because I'm going to click on that as my first read. I saw it in my treatise. It comes up no matter what I try to narrow things down by. It's first, so let's go for it. I'm going to click over here on Thing be Lechuza. Okay, now this is the case. Here we are. What do I want to look at and what's important for me? So the first thing I want to say is obviously you're going to want to start with the case summary so that you can kind of get an idea about what the basis of the opinion is about. Tells you how the court held. But then I actually would scoot straight to the head notes, okay? The head notes are all the major points of law that are brought up to the front of the case so that you can see, what is the most important thing for you to be looking at. Right now, you have a lot of information. You know the element that's debatable for you. You know your legally significant fact. So you can look at these head notes and really give yourself a good idea about what part of the case is most important to you. That's the first thing with the head notes. The second thing I want to talk about is this. Once you find one case, you can do so much with that one case to find a ton of other cases like it. It's really easy to expand your research once you get that one good case. That's all you need, just one case to start off. So where do you get your one case? Generally speaking, you can get it from the treatise, you can get it from the topic summaries. There's a lot of places that you can start off with your one good case. So right now, I'm going to say the thing vi lechuza is going to be my one great case that I'm going to start off with right now. I read it, it's on point, and I like it. So what can I do with this case to find more cases like it? There's a couple different ways that you can do this. And just to go off script, at this point, if you want to show the legal issue trail, that's a good idea. Or you can show shepherdize by this headnote, which is actually what I do, depending on what their legal research level is. You know, how good is their research program? That'll let me know what I'm going to show them. So generally, I would show shepherdize by headnote. Okay, so once you, so now I'm back. So now I look at the headnotes. So what headnote do you want to pick in order to find more cases like this one headnote? Well, generally, the criteria that I use to decide is I pick the headnote that sets out all my elements, which in my circumstance would be headnote number 1. Or I would scroll down and I would try to find a headnote that talks specifically about closely related, my element that's most at issue for me. I would do one of those two things. So for my purposes, what I'm going to do is I'm going to go right here and I'm going to click on I'm choosing headnote number 1 based on the criteria I just laid out. And I'm going to click shepherdize narrow by this headnote. Okay, so what does that mean? That means that you are using the power of shepherds, which is, I know you guys know this, but it's the way for you to check and make sure your case is still good law. This Shepherds has been around 140 years. It is used extensively by attorneys, not only to verify that they are citing good law to the court, but also to expand their research. So for our purposes, for just this moment, we are going to be using Shepherds to find more cases like the case that we like. What's great about it is that we actually have real people that sit and read all the cases, and they go and make connections between one case and the next. So now I'm going to find out, okay, I'm going to shepherdize this case, and I'm going to find out all the cases that have ever also cited to this idea. So I'm going to click over here on Shepherds. It's a very efficient way for you to expand your research. Okay, so I see here that I have 179 cases that have cited to thing vi lechuza, my great case that I have found, but also cite to this headnote you can see here because it's narrowed by 1. Now, from here you might think, okay, 179 cases, that's kind of a lot. Yes, but there are a lot of other really good ways that you can narrow down to get yourself an on-point answer set. You can narrow by what all the positive stuff that people say about this case. This is in the same way that you might be interested in finding, a great restaurant on Yelp, and you want to only find good restaurants that people have good things to say. Sometimes you say, well, wait a second, did anyone say anything bad about it? And then you'd focus on the negative treatment of that particular case or that particular review in Yelp, or something Yelp doesn't have. You can search inside your results the same way you did on your site list. So how would you narrow your 179 cases to cases you really want to read? You would apply the same narrowing rules that I gave you on our case site list here. So that means you would say, okay, well, I'm going to narrow down my element that's most at issue for me. Wait, I did it again. Hang on. Closely related. Okay, I'm just going to narrow it down by that. And then, of course, I have all my other rules that are also available for me. Okay, that gave me 149. Okay, so that wasn't so good. So now what you want to do is you're like, you know what? Maybe now I'm narrowed down by the intersection between fact and law, which is what we always talked about. So I can say closely related. Oh, sorry. Same paragraph as, and I can say relative or family, and then click search. So now so the answer set, just so that we can really understand what do these 20 cases mean? These are 20 cases that cite to thing vi lechuza, my great case, also have that same head note inside of there that gave me all the elements, and use the word closely related and closely related within the same paragraph as a relative or family, my intersection between fact and law. This is a really nice set of cases that you can use to start reading and figuring out whether or not you like the case or you don't like the case. Okay, I have one more thing to cover, and then the class is over. And then, of course, just another word on Shepard's. Obviously, when you get your list of 10 cases that you're going to cite and submit to your writing department, you want to make sure that you Shepardize them to make sure that the cases are still considered good law. I'm going to click up here, and I'm going to bring back thing v. Lechuza. Okay, so I want you guys to follow me. So we can bring thing v. Lechuza back up. And I just want to end the class with giving you a little bit of criteria about how you choose a good case, okay? Your professors say, give me your top 10 cases. What do you guys think are the best? Well, sometimes you read them and you're like, well, I don't know. They sound okay. Let me give you some criteria, some rules that you can use to pick good cases, okay? The first thing I'm going to tell you is this. Whether or not a case is factually on point is not as important as whether or not the case is legally on point. You are looking for, and what I mean by that is that you are looking for a case that is going to give a long discussion of the elements, each and every element. There was 4 elements in my cause of action. I know I have come across a good case when the court has spent a long time laying out each element and what that element means. What facts need to be present in order for you to meet that element? So for me, I know that closely related is the debatable big element for me. So I know I have come to a good case when the court spends a long time talking about, well, is this closely related? What does it mean? Define it for me. I might go down to my head note number 1 and click on it, and then this gives me the background. I scroll down here and I'm looking. I can tell that this is going to give me a nice discussion. Limitations and negligence actions. It's laying out the major rules for me and how my facts are going to measure up. So I can actually go up here to jump 2 and click here and see exactly where closely related reads and read about it. And I want to see how good of the discussion the court is giving me about closely related. And that's how I know I found a good case. You want to find something, again, that gives a very robust discussion of the legal issues and what you need, what kind of criteria or standards or you need to meet that element. Because that's your work as a lawyer, is to argue to the court, look, we meet all the elements, therefore we win. So you want to see a court, you know you got a good case when the court in your case that you're picking is spending a lot of time doing just that. Oh, they met these 4 elements and here's why. So you can then use that case and apply it to your set of facts. You want to take the case that's right on point and apply it to your set of facts. So again, the fact that you don't, just because you see a case that's extremely factually on point doesn't necessarily mean it's a great case if the law is not on point. If they spend all their time talking about an element that you've already met. Okay, so if you guys have any questions, I am here after class, and I want to say this just about support options. I know I covered a lot of information, and I can tell that you guys were really following along, which is good. Sometimes though, when you and I were not hanging out together, and you go to do this on your own, even though you brought the handout and stuff, you might think, well, wait a second, what did she mean by this? Or, oh, wait, I kind of have a question. Don't sweat it. I'm around. You can send me a note and we can work it out over email, or if you want, I can I'm here all the time and I can meet with you individually. So I'm available if you are in that situation at 2:30 in the morning. You're like, wait, what? Also, my Lexis associates are also available for you, to discuss navigational issues. We can't talk about the actual facts of your case, but we can talk about kind of the legal process, the legal research process, and how to navigate. So we're around, and if it is 2:30 in the morning and I'm not on my email, which is highly likely, um, you can always go to life support, and you can link out to more now. There we go. You can look for, you can get into a chat room with somebody from Lexis. They're like little me's, okay, attorneys that can help you kind of navigate through. All right. Thanks a lot for coming, you guys. Please make sure to sign the sign-in sheet, and good luck with your assignment.